Picture the glass doors of the Federal Trade Commission on a gray March morning. A guard stands beside a simple notice taped to the inside. Commissioner Rebecca Kelly Slaughter, office vacant. Inside, the nameplate on her desk still shines, though the seat is empty. Passers-by glance, uncertain what this means, whether a president's will may sweep through even an office meant to stand apart. That small scene may seem personal, yet it reaches all the way to the heart of our Constitution. For if one order can silence the independent voice of a commission, what wall still stands between power and restraint? I mean to speak of that wall today, and of what it protects. Picture the marble steps of the Supreme Court on December 8, 2025. A chill wind carries the words, Trump versus Slaughter, into the Great Hall. Inside, 9 justices listen. Can a president remove an officer who, by law, was promised independence? The lawyers invoke an old case, Humphrey's Executor of 1935, when another president dismissed another commissioner of the same agency. Then, the court said no. Today, some justices ask whether that old answer still holds. Why does one firing matter so much? Because underneath lies a question as old as our republic. Must power be whole to be useful, or divided to be safe? It is said that the executive must have unity, that one elected hand should guide all beneath it. This thinking argues that voters can hold one leader responsible for success or failure. But the law warned long ago that absolute command may quicken action but weaken safety. The people who wrote our Constitution feared a government too swift for its own conscience. Think of Franklin Roosevelt's day, when the Humphrey's Executor case first arose. Picture the Department of Justice in 1935. Rows of typewriters clacking, clerks whispering that the president had gone too far by firing an FTC commissioner named William Humphrey. The court answered then that some officers must be able to judge and act without fear of dismissal. That decision built the world of independent agencies we live with now. Over time, those agencies multiplied. The SEC to guard investors, the NLRB to balance labor and business, the Federal Reserve to keep the nation's money stable. Their decisions shape our work, our homes, our daily bread. Yet today, their very independence stands trial. The Supreme Court granted special hearing, skipping the usual appeal. The stakes were called too great to wait. Each side entered with earnest conviction. The president's lawyers claimed that true accountability requires power to remove. Slaughter's counsel replied that without some shield of tenure, the law itself tilts toward politics. Between those tables sat a deeper question no brief could answer. What kind of government do we wish to be? But before we answer that, we must recall why the founders did not trust power gathered in one hand. When this nation was framed, the people had seen kings who ruled by whim. They divided powers not to make government weak, but to make it honest. The legislative was to write, the executive to carry out, the judiciary to check both. Yet as the republic grew, new needs arose beyond those simple lines. Commerce, credit, competition, these asked for specialists who could stand between law and politics. Imagine a hearing room on Capitol Hill as Congress debated the Federal Trade Commission Act. Lawmakers spoke of a board neither political nor judicial, but administrative and fair. They wrote in terms of independence, not to defy presidents, but to defend the public from hasty change. Still, they gave each commissioner a fixed term, bound by cause if removed. They sought balance. Here lies the first gap for us to ponder. Can independence so designed to protect law become, in time, a barrier to it? That doubt haunts every age. The same law that grants safety can, when stretched, breed arrogance. Some say agency staff have grown too distant from the people, writing rules by pen unseen. Others warn that if presidency alone commands them, the whole civil order becomes one man's arm. Which danger weighs heavier? The Constitution offers no simple solution. It offers structure instead. It divides to unite, limits to preserve power, not to remove it. Balance itself is the design. Picture the bright lamps of the Supreme Court Library, glowing over leather-bound volumes of precedent. There rest the words of Free Enterprise Fund v. PCAOB, and Sailor Law v. CFPB. In those pages, the court trimmed back layers of protection too thick, reminding agencies that they still fall within the executive, yet it stopped short of removing all walls. Some independence, the opinion said, but not isolation. The court spoke of a chain of command, but with lawful links. Another question opens before us. If power must act to be effective, how shall it keep its soul while it acts? I have seen in my day that strength and conscience do not always travel together. During the Great War for Union, I felt the push of necessity against the pull of law. We held firm to the rule that even in emergency, the Constitution bends, but does not break. So too with the powers of office today. The President's oath binds him to execute the laws, not to erase them by command. Still, not every officer deserves immunity. One who defies lawful duty invites removal. The issue is not whether a president can ever act, but whether he alone decides when cause exists. If the law sets rules, those rules guard both president and people. No man should wish for freedom to act against law, for such freedom, once begun, devours itself. Picture the conference table of the Federal Reserve, where governors debate interest rates that affect millions. Some now ask whether they too shall serve at the president's will. If the court in Trump versus Slaughter finds that independents must bow, those governors may look over their shoulders before casting each vote. And once they do, markets may come to doubt not the policy, but the permanence of our law. When trust trembles, money, like faith, takes flight. Picture the quiet hallway outside the Federal Reserve boardroom, the seal of the United States shining on the wall. An aide walks past, carrying a folder marked Rates. But what he carries is the country's confidence. Such unseen acts of service depend not on fear, but on duty. They depend on the knowledge that reason, not orders, commands the mind. From these rooms of policy back to that single paper on a glass door, the story is the same. How shall free men serve power without becoming its servants? This is the heart of the matter, and it has beaten the same since the founding. Every generation must decide whether the law rules men or men rule the law. Yet the hard truth is that divided authority demands something deeper than law alone. It demands trust. Without trust between the branches, parchment grants no restraint. Without honor in both giver and keeper, rules are but shells. When a president obeys a statute he dislikes, and when a commissioner enforces a rule she did not write, that is the unseen virtue that makes freedom orderly. Think of Congress in 1935, drafting those removal clauses by lamplight. Some wanted to yield to the executive for speed, others to the legislature for oversight, but the final hand wrote that a man may be removed for inefficiency, neglect, or malfeasance. 3 small words that bind 2 mighty powers together. They are neither sword nor shield, they are a test of character. Character is the unseen hinge of the Constitution. It cannot be printed into law, it must be practiced. When duty triumphs over pride, the Republic breathes easy. When pride outgrows duty, government hardens, first into rivalry, then into rule by will alone. Now, some say the Constitution should evolve with need, that in a modern age, independence slows progress. They point to technology, to crisis, to global tide, and ask why patience should be prized. Their longing for direct control springs from honest desire to act. But even noble haste can turn reckless when it forgets why limits exist. A horse that runs straight to the cliff still obeys its rider. Others, too, err in the opposite way. Fearing misuse, they would make every agency untouchable. But permanence does not mean purity. Sometimes the people must recall those who no longer serve them. Law without responsiveness grows brittle. It cannot bend under change, and soon it breaks. So we walk the narrow road between vigor and restraint. It is a road of conscience. It has no end, only guidance. The guidance is self-government itself, the belief that no office, however high, owns the public trust. It merely stewards it for a time. To see what happens when that trust fails, we must glimpse our own history for warning. Picture the chamber of the U.S. Senate in 1868. The air is thick with dust and discord. They sit in judgment of a president, Andrew Johnson, who claimed the right to remove his own Secretary of War in defiance of Congress. The Tenure of Office Act then forbade it. Johnson stood on the same ground the court hears today, that the executive must be free to command subordinates. Yet the Senate stood for balance. The nation, divided and weary, hung between them. Johnson survived by a single vote. But that vote saved not the man so much as the measure of the presidency itself. It reminded all that power must operate within design, not in defiance of it. The law later repealed the act as too rigid, but the lesson endures. Restraint cannot be one-sided. Each branch must bear it equally. That lesson traveled forward through Roosevelt, Truman, Nixon, and every successor. Some sought to bend agencies, some sought to dissolve them. Each time, the balance bent but did not break, because enough among them remembered that they were trustees, not owners, of authority. Still, knowing is not the same as doing, and the test of our time is upon us again. Picture the courtroom once more. Trump Vera slaughter, now under deliberation. The benches are empty, the echoes of argument fade. Clerks pore over history, comparing 1935 with 2025. Outside, reporters trade guesses. Inside, silence rules. In that quiet hangs the same question the framers left us. Will ambition still be made to counteract ambition? If the court speaks to uphold independence, it will remind us that no victory for one branch can outlast the Republic itself. If it narrows that independence, it must still proclaim that law, not personal will, guides the nation's course. For even the strongest hand needs the compass of principle. Now is no hour for triumph or fear. It is a time for reflection, for each citizen to recall why freedom rests on structure, not sentiment. When lines blur between offices, the people must redraw them not with anger, but with care. The remedy for confusion is understanding. The cure for division is perspective. Pull forward. And that perspective must begin not in courts or capitals, but within the hearts of ordinary Americans. Picture a teacher in Des Moines, drawing the Constitution's 3 branches on a chalkboard. Picture a factory foreman in Toledo, scanning a newspaper about the court's ruling while the lunch whistle blows. Picture a young law clerk in San Francisco, reading old Federalist papers by moonlight, seeking not argument, but wisdom. These quiet acts hold the real safeguard of the Republic, an informed, temperate citizenry. For the lasting power of our government lies not in its officers, but in the people's habit of holding them accountable with patience, not fury. Every time we ask, what is lawful, not what is convenient, we breathe new life into the old design. The story of Commissioner Slaughter will fade from headlines, but its echo will remain. Somewhere, another president will face another test of authority. Somewhere, another humble officer will weigh obedience against duty. The chain of restraint must be forged anew in each of them. When you hear men speak of power as efficiency, ask them what they mean by good government. When they promise swift action, ask them by what right they act. For law is not the enemy of progress, it is its conscience. Picture the night falling over Washington, the gleam of the FTC windows, the dome of the Capitol, the silent pillars of the court. They stand apart, yet together. Their strength lies in that distance. Each limits the other so that all may endure. Let this be our plain truth. Constitutional government does not protect itself. It depends on steady hands, on leaders of discipline, on citizens of good judgment. A republic may falter from neglect as easily as from abuse. Our defense is never outrage but reason, never vengeance but vigilance. As we remember, we may speak with calm conviction. America's strength is her unity. And unity is not sameness. It is harmony among lawful parts. It is the courage to differ without dividing, to question without breaking faith. May we hold that courage again. Tell me, fellow citizens, when the time comes for each of us to choose between will and law, between speed and duty, which will we honor?